Hi, I'm Mike Sachs with Court Accountability Action, and I'm coming at you on Legal AF with the Midas Touch Network to talk one of the latest of President Trump's executive orders. Now, this one is sort of like that movie Minority Report, you know, where there were those precogs laying in some weird bath with their eyes open, seeing the future, and that would direct how the government, this weird dystopian totalitarian government, would direct law enforcement in the future to get people before they committed a crime. Well, that's what this new executive order that was issued this week is all about. So this order is called Directing the Repeal of Unlawful Regulations. Sounds boring, regulations, whatever. But this is actually a centerpiece of the right-wing legal movement. This is a priority, if you will, of the corporations and the plutocrats who are trying to make sure that they can amass and keep as much of their billions as possible and get more from the working people. And so the rest of us don't get as much. The rest of us don't have the air quality or the or the economy or the auto safety or the religious freedom or equality that this country guarantees us. So I want to dive in here for a second and tell you why this is like the movie Minority Report. So this, I'm looking at right now, this executive action, is pretty much saying this. I'm going to just read it quite clearly. The president's authorizing DOGE to identify certain categories of unlawful and potentially unlawful regulations within 60 days and begin plans to repeal them. This review and repeal effort shall prioritize, in particular, evaluating each existing regulation's lawfulness under the following United States Supreme Court decisions. And it lists 10 Supreme Court decisions that pretty much cover regulatory policy, environmental policy, workers' rights, unionization, and religious exemptions, pretty much putting allowing churches to use public funds for their own sectarian purposes, and to exempt themselves from generally applicable laws like, COVID restrictions like we had before, as if that's going to happen again in the next century. Well, it might, given the government and the HHS we have right now. But, okay, so is it listing these 10 Supreme Court precedents that were all big wins for the right-wing legal movement, that were saying that certain regulations that were put forward in previous administrations, a lot of them came from the Biden or the Obama administrations, or were just practices like affirmative action that have been around for years. All of these, they're saying all of these decisions mean that a whole bunch of regulations that have yet to be identified but are still in the Federal Register where all these regulations are codified, that they are all unconstitutional, all illegal, all unlawful. Now, yes, the executive branch has the right to decide what is and what isn't unlawful. That's part of it. Every branch can judge for itself what goes within the Constitution or what doesn't. But there's a process by which these have to be followed. And it's not just, oh, I think the Supreme Court will strike this down, so we can just repeal it without worrying about the process. And that process matters as well to make sure that our regulations, our rules are fairly put forward, represent the will of the people, and are well considered before they're either enacted or repealed. Remember when Trump tried to repeal DACA during his first term, and they cut corners. They had a really perfunctory explanation for why they're getting rid of it, because they thought the Supreme Court would strike it down based on its previous rulings on an expanded DACA for parents under the Obama administration. Well, they tried it back then, and the Supreme Court didn't buy it and wouldn't let him rescind DACA based on just a little letter. But in this executive order, what it comes down to is this. Trump writes, whoever wrote this for Trump, wrote that notice and comment proceedings, which again are pillars for the process by law under what's something called the Administrative Procedure Act. It's a law that all federal agencies have to follow in order to put forward and rescind rules. It says, furthermore, notice and comment proceedings are unnecessary, in quote marks, where repeal is required as a matter of law to ensure consistency with a ruling of the United States Supreme Court. Agencies thus have ample cause and the legal authority to immediately repeal unlawful regulations. They do not. They do not. This is where we get to the Minority Report stuff. This is precog stuff. They're now ordering people, or they're having DOGE go through the federal government, go through the agency heads, and find different regulations that may have been put forward back before all these 10 decisions were made by the Supreme Court, and said, yeah, those are illegal. You can get rid of them. We don't have to worry about them because we think the Supreme Court is going to say that these are unlawful. DOGE is going to be our precogs. Now, let's get back to DOGE, because this is the thing. This whole executive order is the ghost of Vivek Ramaswamy. Why do I say that? Because back in November 20th, 2024, the Wall Street Journal opinion pages published an op-ed by Elon Musk and Vivek Ramaswamy. The DOGE plan to reform government, following the Supreme Court's guidance, will reverse a decades-long executive power grab. That was how they framed this. Now, this was the original DOGE plan, which was Vivek Ramaswamy's position before he got defenestrated, or, nicely parted ways to run for another office. But before Musk took over and made DOGE into this whole thing, this chainsaw of federal jobs and federal funding that has already been guaranteed under congressional mandated appropriations, before Elon Musk made DOGE an organization that steals Congress's power of the purse, which Congress is not doing anything to fight back against, even though it's its core constitutional power. So to enrich himself and to pretty much just buzzsaw down federal workers, their jobs, their families, and their livelihoods, and federal funding that helps people survive and make the world a better place and educate our children and preserves the lives of people in other countries. So to preserve goodwill towards this country, and also just because it's a good thing to make sure epidemics don't spread around the world so they don't come back here. So anyway, I digress. But in this op-ed in November, when they announced DOGE, the way it was originally meant to be, we will focus particularly on driving change through executive action based on existing legislation rather than passing new laws. Our North Star for reform will be the U.S. Constitution, with a focus on two critical Supreme Court rulings issued during President Biden's tenure. It cites West Virginia versus EPA and Loper Bright versus Raimondo. Those are 2022 and 2024 cases, respectively. And those are also the first two cases listed in the executive order that was issued just this week. And in doing so, they said that together these cases suggest that a plethora of current federal regulations exceed the authority Congress has granted under the law. They suggest, but the Supreme Court said so yet? No. Does that give them license to just buzzsaw these regulations down? Oftentimes, or again, they're meant for keeping a good environment, health and safety of our children, our families, our communities. These are things that were passed before these Supreme Court precedents were law, and still subject to the same notice and comment provisions that protect us from having an arbitrary executive branch. But no, DOGE will work with legal experts embedded in government agencies aided by advanced technology to apply these rulings to federal regulations enacted by such agencies. They'll present this list of regulations to Trump, who can, by executive action, immediately pause the enforcement of those regulations and initiate the process for review and rescission. There it is. That was a Vivek Ramaswamy idea, and people perhaps might have thought that wasn't coming back once he got defenestrated. But it is back in this executive order. And mind you, that op-ed was what had people lighting their hair on fire back then, because this is a patently unlawful proposition. Patently unlawful. If they want to go through the right processes and actually go for repealing it in the way that the law provides, go for it. Why not? That's how this country of laws, not men, work. It would be unpopular, perhaps. Maybe it wouldn't. But at least it would be consistent with our rule of law, instead of a raw executive power grab that they're claiming they are fighting. So a lot of projection going on here. But ultimately, we are seeing the return of Vivek Ramaswamy's ghost in this executive order. And it's creating a whole precog system, straight out of the movie Minority Report, towards our country's very health, safety, consumer protection laws, and many more things based on these 10 cases that are listed in the EO. I recommend you all check it out. I recommend you hit that subscribe button. I hope this has helped you understand what's going on, which can be sometimes arcane in this world, but that's what Legal AF is for. I'm Mike Sachs. Thanks for watching.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.